Hey, all right, on to implied terms, the obligation of good faith, and warranties. So, implied obligation of good faith is first. Just a weird. No, implied terms. What is implied from a contract? What is not said, but it is implied either in certain contracts or all contracts. So some examples of implied terms, and you can call this living between the lines or blurred lines. So we're looking at best efforts, reasonable notification, good faith discretion. So this is the Lucy Lady Duff Gordon. We like her name, Lucy Lady Duff Gordon. I thought it was a dog at first. It's a woman, not a dog. Rude. Okay, Lady Duff Gordon's argument. So she was a fashion designer, and then she gave her exclusive trademark to someone else to market, but then they didn't do anything, and so she sued. Or no, so then she sold some of her other stuff, but he had an exclusive agreement, and he said, well, you breached our contract, and she was like, no, you breached our contract. And so the question is, was there an implied obligation in the contract? Because it didn't say he had to. And so Lady Duff's argument was there's no contract because Wood provided no promise and therefore no consideration. But the court said there is a contract. Okay, so Lady Duff actually said there is no contract because there was no promise and no consideration, but the court said there was, and Woods, they came to court with the contention that Lady Duff Gordon said there was no promise here for anything, there was only my consideration to him, and if he didn't do anything, he got no consideration, so no contract, because that was all she really could say. And Wood said, no, there was a contract and you owe me money and I don't have to do, I get to choose what I do. And the court said, Lady Duff, there is a contract, but. And so the defendant gave an exclusive privilege. She was to have no right for at least a year to place her own endorsements or market her own designs except through an agency of the plaintiff. The acceptance of the exclusive agency was an assumption of duties. So was this an implied promise or an illusory promise, which is a choice, and we learned earlier if the promise is implied, we're going to go one way, and that's how we're going to go in this case. But if it's an illusory promise, then it means that in one side, doing something would have consideration, but not doing something would have no consideration. It's like if you move into my house and you can move into my house if you make dinner every night, or if you just sit on the couch and watch TV. Well, sitting on the couch and watching TV is not consideration, and therefore the whole thing won't work. So an illusory won't work. So the court says it's not illusory because unless he gave his efforts, she could never get anything. Without an implied promise, the transaction cannot have such business. Efficacy of both parties must have intended that at all events it should have. That doesn't make any sense. It's Old English. Okay, so the restatement 77, illustration 9 says, a promise to pay B half of any profits. So when you have a character in a hypo named A, it's really hard when you start the question with A's name because you think you're just saying a promise, but you're not. You're saying A promises to pay B half of any profits he derives from the sale of goods manufactured by B. In return, B promises that A shall have the exclusive right to market such goods. The promises are consideration for each other, since the agreement for exclusive dealing imposes an obligation on A to use best efforts to promote sale of the goods, and on B to use best efforts to supply them. So this is not only the restatement, but this also goes to Commercial Code 3062, which says a lawful agreement by either the seller or the buyer for exclusive dealing in the kind of goods concerned imposes, unless otherwise agreed on, an obligation by the seller to use best efforts to supply the goods and by the buyer to use best efforts to promote the sale. So this is an implied obligation of good faith. 2309 says absence of specific time provisions, notice of termination. So now we're going to go into reasonable time. So contracts that say you will use your work to promote whatever we're doing have an implied obligation of good faith. And then now we have a notice of termination. It keeps absence of specific time provisions, notice of termination. Otherwise, it keeps going until one terminates with reasonable notification. So where the contract provides for successive performances but is indifferent in duration, it is valid for a reasonable time, but unless otherwise agreed, may be terminated at any time by either party. Termination of a contract by one party, except on the happening of an agreed event, requires that reasonable notification be received by the other party, and an agreement dispensing with notification is invalid if its operation would be unconscionable. Okay, so we're going to talk a little more about that as we go into libel and Rayner Manufacturing. So the parties here, one had an exclusive contract for dealing in something, which required a lot of inventory. Libel then said, like, oh, we're canceling your contract, we have another dealer, we're going this way. And they said it wasn't reasonable time because, well, we'll talk about the reasons. You need to sell off inventory, you need you need time to recoup your investment before. So a reasonable time is not just like, well, I told you. It's not reasonable if there's more things involved. So in this case, defendant's three-part argument, the UCC does not apply here because it's a service it's a retailer agreement, so it's the services of selling, not the actual just goods. No, that's not right. Okay, the defendant says that. That's his argument. The court says, no, UCC applies. You are a seller. And then the defendant says, okay, well, even if the UCC applies, there's only need for actual notice here. The court's conclusion, UCC requires reasonable notification, which concerns the circumstances surrounding notice, not just the method of providing notice. And then the defendant says, well, requiring reasonable notification would amount to making a contract for the parties by stating a time of duration for the contract. And the court says, no, it doesn't. I mean, it makes a termination agreement, and maybe you should have done that. Otherwise, you just need to be reasonable, which is a term we use all the time in law school. What is reasonable? We can never agree. Subsection 3 recognizes that the application of principles of good faith and sound commercial practice normally call for such notification of the termination of a going contract relationship as will give the other party reasonable time to seek a substitute agreement. An agreement dispensing with notification or limiting the time for the seeking of a substitute arrangement is, of course, valid under this subsection unless the results of putting it into operation would be the creation of an unconscionable state of affairs. So, like, you can contract around a reasonable time. You can say, we're going to end, the moment either party wants out. You can do that. If you don't, it's going to be a reasonable time. What constitutes reasonable notice? Enough notice for unwinding. Sell off inventory, have time to if you have a substantial unrecouped investment, so like big machinery that you're selling, it's going to take more time than just like, hey, you're no longer a person. Peace out. Why have implied terms? Legal rules that will make contracts shorter. Default rules people can choose to contract around. For morality, we want to make good faith contracts. Although we've also said contracts aren't moral. It's either you do it or you don't. We're not going to place a judgment on there, so maybe not moral. And then economic efficiency. There's lower transaction costs, so like you can buy seats off the rack. And then that also means less drafting hours for lawyers. So the good faith and fair dealing. This is the Locke versus Warner Brothers, the John Wayne case. Restatement 205, duty of good faith and fair dealing. Every contract imposes upon each party a duty of good faith and fair dealing in its performance and its enforcement. So John Wayne's ex was given a development contract as part of her divorce decree. Sketch. And Warner Brothers never intended to use her for anything. However, so basically from the case, how parties may limit the obligation by expressly providing in the contract, which they didn't do a good job of apparently. So the general rule regarding the covenant of good faith is plainly subject to the exception that the parties may, by express provision of the contract, grant the right to engage in the very activities in contract which would otherwise be forbidden by an implied covenant of good faith and fair dealing. So she had we will look at your stuff, we get first right to it. If we say no, you can send it to someone else. And instead of looking at it, they just said no, because they didn't really want to work with her. So it was easy for them to say no, but they didn't look at it. And had they said, we reserve the right not to look at it in our decision, that would have been fine. They can contract those types of things, but they can't just do it. So where a contract confers on one party a discretionary power affecting the rights of the other, a duty is imposed to exercise the discretion in good faith and in accordance with fair dealing. So they said this wasn't in good faith. It is settled that in every contract there is an implied covenant that neither party will do anything which will have the effect of destroying or injuring the right of the other party to receive the fruits of the contract. Again, this could be argued that she still got the fruits of the contract because she wasn't hindered from sending it anywhere else, but the court said no. Where the contract involves matters of fancy, taste, or judgment, the promisor is the sole judge of his satisfaction. If he asserts in good faith that he is not satisfied, there can be no inquiry into the reasonableness of this attitude. But that means that he's got to at least look at what's there. And because Warner Brothers didn't even look, they broke it. They didn't have good faith dealing. Example but in this case, if you are painting a portrait, you're writing something, you're producing a play, and the person who commissioned it said, no, hate it. They have the right, and you can't, fight them about that. It's their taste. Court finds that there is sufficient facts to reverse dismissal of Locke's claim on Warner's breach of the implied obligation of good faith and fair dealing. The Locke-Warner agreement did not give Warner the express right to refrain from working with Locke. Rather, the agreement gave Warner discretion with respect to developing Locke's projects. The implied covenant of good faith and fair dealing obligated Warner to exercise that discretion honestly and in good faith. Because honestly, she probably wouldn't have agreed to it if they said, listen, we're just giving you money. We're not really going to use you. Ever. Yeah. So that's that.